We have a person named Kenyana Stone.
Let's clear the air once and for all. Kenyana Stone didn't win anything. She lied on Facebook Live again. She submitted a fake $1.7 million check to buy a home, got rejected, and followed it up with a fraudulent UCC1 lien that the court tossed like yesterday's trash. That's not a win, that's desperation. Meanwhile, Thomas and the New Culture Empire are on another level entirely. We deal in real accounting, real securities law, real federal and consumer protections. We understand court filings, court rules, and actual court procedure. And unlike these template-selling, struggling paycheck-to-paycheck gurus, we're backed by former SEC attorneys, ex-Deloitte executives, and World Bank insiders, not vibes and TikTok clout. The New Culture doesn't just expose lies, it buries them by replacing misinformation with real understanding. No more YouTube law, no more Facebook packets pretending every case is the same. Courts don't rule on templates, they rule on facts, numbers, and procedure. No more free PDF sovereignty. If your legal strategy fits in a downloadable packet, you're already losing. Courts don't reward copy-paste law, they punish it. No more desperate hustle, masked as mentorship. 2026 is the year of Setu, the Supreme Elite Team University. We're not playing nice and we're not playing broke.
Actually, she was just live on, actually, she went live a couple times. She went live quite a few times. And the live was based on the comments I made on her videos, the comments I made on her channel. I sent her the link to this on Facebook Messenger. The comments that I made about her and her teachings. Now, before we get there, I knew nothing about this person. I knew nothing about this person. I could care less about this person because remember when I said when you have professionals on your team, when you have professionals on your team that could substantiate everything that you're saying, you don't really care about what anybody else says. So she kept coming across my radar, and this is how she kept coming across my radar. This is how she kept coming across my radar. So it started. This is one of them. Bro, do you know of her? You know her or of her? She's from India, my city, but it's like every time you start a topic on something, she's doing the same thing or similar. Now, this is the most recent one. But normally I get that all the time. I mean, I got that with Midwest. You know, I got that with a lot of people who watches me in the clouds, tries to dissect what I'm saying on live, runs back to their groups with brand new talking points. Because, as I've been saying before, and I will continue to say, I am your teacher's teacher. Yo, you said that yesterday. Now they saying this today. But I've been watching their stuff for 2 years, and they've never said nothing. But I vividly remember you saying that. Now they switched course. Now they want to talk about accounting. Now they want to talk about securities. Now they want everything is private instruments, negotiable instruments, jurisdiction of the court. It's nothing on the rail that I'm talking about. So this is not a one-off. I've been getting this for multiple, but this one is very particular because a lot of people kept sending me the same things. And I never responded. You know, my response is, well, they better have understanding. You can't just think they're going to run from you just because you bring up some E and all that. or just because you can repeat what someone
is why
says. You can hear them talk about it, or they can preach about it, but you don't really see them tying it all together.
That boy is good.
Because that's just one major aspect of it. It's not a little aspect, it's a major aspect of it. But they don't know how to translate it into a legal claim. And Kenyana Stone, I gave you the opportunity to come up. I sent you the link privately. I sent you the link on Facebook. I can go back on her Facebook group. It's Kenyana Stone. She added me, the new coach of Empire. She was saying things like, oh, it's a documentary draft. Oh, that's cash. She said, oh, their purchase order is cash. Y'all, remember we've been dissecting those things? The purchase order is cash.
I can feel your desperation.
Oh, I purchased the home.
Stop lying.
Remember that? Remember those things? And just in case, here's the link. So I sent her that. So going back to, I kept hearing about her. And then I went on her page and I asked the question months ago. And of course, no answer, because you can cite out all the accounting stuff that you hear other people talk about. See, you can cite that all out. You can cite it out all you want. But being able to cite it and regurgitate it does not mean anything unless you can tie it into a legal claim. And look, she said they stole $200K, but she used a negotiable instrument on check paper like Elliot was doing with the IRS, and they wasn't going for that. They could have said she tried to use a fake check, because that's exactly what she tried to use to purchase the home.
Oh, this night just keeps getting better.
Kenyana Stone, with all this so-called accounting knowledge and all this, knows how to go to court and win. She actually lost her case.
But before we proceed with the highlights of this live stream, we have to go to a quick commercial break.
This isn't just a case, it's a revolution. While others chase trends, we forge our own path. Welcome to the New Culture Empire, led by Lamont Thomas. With over 10,000 hours of research, he's cracked the code. He connects the dots between complex laws and consumer rights. Imagine having the power of top litigators at your fingertips. Thomas has achieved what less than 1% of consumers acting on their own behalf can ever dream of achieving. The studies show that 99% of consumers representing themselves fail to meet the requirements of FRCP Rules 8A and 9B. His filings are recognized by federal courts as groundbreaking. Lamont's complaint survived the initial screening and raised viable federal claims involving highly complex accounting and securities issues. One might ask, what does accounting and securities laws have to do with a consumer contract? And the answer is, unless you're a top professional or part of the SET, you probably won't ever find it on platforms like YouTube University or Disgracebook. This is the magic the SEC attorney told Lamont that less than 10% of attorneys who's had 15 years of practice doesn't even understand. If only 10% of attorneys understands that magic, you can only imagine the percentage of consumers without any courtroom experience, from online social media teachers and those only looking to make a quick buck off of packages that they themselves do not put into real action. The secret is, they take your money to pay their bills while giving you a bogus instrument or documents to submit in hopes of you getting out of your own obligations. Students of the Supreme Elite team are easily recognized in other streams of gurus because, from learning from Lamont, they too can spot out the fake ones, whose only advantage is that the ones listening to them are more ignorant than they are. The SET students, or anyone who even questions a guru or seeks clarity, are blocked from their live streams. Think about that for a second. In professional settings, questions are routinely asked to gain understanding and clarity, while asking the gurus questions are interpreted as trolling. Don't be fooled. That's their conscious and them projecting. They believe that your question will expose their ignorance, like they know you are aware of their lack of understanding. That paranoia makes them take any question the wrong way. Real teachers welcome questions and have the understanding to convey the answer in a manner that will bring clarity. What they want are blind followers and will run when challenged, or gaslight, or stretch the truth to save face. That attitude only reveals they are not equipped for litigation or prepared for courtroom settings. When it's all said and done, you'll end up paying more money to the gurus than your initial obligation. Where belief systems governs over the cold, hard facts, it's not a shock why you see multiple online teachers all peddling the same dead-on-arrival documents to only those who believes the system works a certain way, and will deny proper information because it's too hard to understand, or it doesn't comport with their belief system. While the gurus sell packages before they've had their own success, Lamont drops the receipts and is transparent all the way throughout the whole duration of the litigation. Now that, in a world where knowledge is power, we're the insiders. As the year wraps up, our members are already ahead. Don't get lost in the noise. Join us and shape the future. This is the new culture, where knowledge evolves into an empire.
Now, this is the order. I'm just going by in order of how I typed it. This is the order. This cause having come before the court on plaintiff's verified complaint petition for temporary restraining order, and the courts having reviewed the verified petition and appearing that unless the defendant is restrained from taking any action or asserting any right, title, or interest in the real estate, the plaintiffs will suffer irreparable harm. Plaintiff's verified petitioner is plaintiff's verified petitioner is hereby granted.
You're rocking with the best.
So they granted the petition against you. They granted the restraining order against you. You said the restraining order was against them.
What?
This is now y'all see why she had to go live 3 times. It was eating her up. She's like, damn, he caught me. I got to go spin this narrative. It is hereby ordered that defendant and her agents, successors, assigns, attorneys, and persons acting in concert with them shall immediately take in any action or asserting any right, title, or interest in the real estate at the location, Indiana, such that it prevents plaintiff Kimberly Short from completing the sale of the real estate located at there. She wasn't even selling the house to you. She was trying to sell the house to someone else because they closed out your file because they knew you didn't have the real money to pay for it. So you saying the case, there's nothing, this what she tried to say in her lie, that the case is still ongoing. How can you have an ongoing case when they already sold the house to someone? That's an even bigger indicator that what you tried didn't work. They sold the house to someone. But this is the disingenuous part about these gurus. She already knew that.
Emotional, damn it.
But she would still come online, keep acting, people thinking that it's going. And they like, we with your sister. Yeah, keep going. You dummies. You dummies.
It broke.
It is further ordered that the recorder of Marion County shall remove from its records all indications of defendants having any right, title, or interest with respect to the real estate located at 5710 Brentwood Road, Marion County, Indiana, including the UCC finances statement as instrument number blank in the office.
I Googled him. It said legitimate business. I never dreamed the internet would lie. Stupid Flanders.
This is the part where she thinks it has anything to do with her. This is a temporary restraining order. And the feds is under Rule 65. But the case states is quite similar. So the $700,000, they plaintiff, Miss Short, has to put $700,000 in escrow because this is a temporary restraining order. So they have to put $700,000 in escrow just in case Kimberly Short and the attorneys are wrong, because they have to give security to the court in order to, when they grant the temporary restraining order, they have to provide security to the court just in case your injunction or your restraining order has actually harmed another party. That has nothing to do with you getting she thought that security was like hers or a win for her. She didn't even know how to interpret temporary restraining orders under the statute. And if you read the Indiana statute under temporary restraining orders and all other statutes, it tells you the person applying for a temporary restraining order, even in the federal courts, they have to give security to the court to indemnify just in case your TRO or your injunction was unnecessary and it caused harm to the other party. But in her mind, she thought that was something favorable for her.
You serious?
That's all. Look, somebody look, I swear it's it. And she thought she was about to win. I told you, they all misinterpret statutes. They have no understanding of what they're reading. They take it at a literal. She don't understand this is in conjunction, because if you read here, it says, but it is contingent on the sale of the property. So during this proceeding, if Ms. Short sells the property to someone else, $700,000 has to remain in escrow until this is over with. Duh. I told you. It's no different. It's the same thing with all of them, y'all. They have none of them ever really started out studying deep dive. All packaged documents from other people. Never no thorough understanding. This is Kenyana Stone's answer. Kenyana Stone, I'm not lying on you. This is your answer. At all times relevant herein, Kenyana Shakur Stone, the lawful diplomat with record of diplomatic status in the United States, organized in the American state Indiana, Kenyana Shakur Stone, having a state nationality as Indigenous American Indianian Hoosier, trustee of, stop right there. So Kenyana Stone, when I said you put that indigenous stuff on your paper and you say, no, you didn't, I didn't know what I was talking about, this is what I meant.
Telling the truth is really, really important.
You might have forgot, but this is what I meant. This is what I meant, Kenyana, when I said you put that indigenous stuff. This is what I meant right here. I meant this right here, Kenyana. This is what I meant. That's what I meant. So there ain't no clear. December 13, 2023, this is filed. The trustee of the Kenyana Shakur Stone Revocable Living Trust is a private trust. Don't we talk about this stuff, y'all? Kenyana Shakur Stone asserts the court may or may not jurisdiction over the subject matter of this action. Proper venue in Marion County, where the real estate property is situated in Marion County, Indiana. Defendant objects and denies the facts presented in paragraphs 1 through 24 in the motion for temporary restraining order and preliminary injunction. Defendant objects to order granting plaintiff's verified petition for temporary restraining order. But Kenyana Stone, I thought you said it was working out in your favor.
I made a mistake.
Why are you objecting? The language that we read with the court should have been reading like it was in your favor. It was all against you. Debt was acquired. Debt has a right of recourse. Perfected UCC finance a statement recorded in Marion County. And before I deep dive into this, I bet you it's a bunch of misinterpretations, lack of context, and baseless assertions for which she believed the statute says versus what the statute means. Want to know why? Because 99.9999% of people read statutes this way.
None of the information is correct.
On June 21st, 2023, Kenyana Shacole Stone and Kimberly Short fully signed and executed a purchase agreement wherein Kenyana Shacole Stone agreed to purchase from Kimberly K. Short the real estate and improvements located at 5710 Brookwood Road, Marion County, Indiana, the real estate. Kenyana Shacole Stone and Kimberly K. Short completely signed the purchase agreement, accepting all offers and counter offers attached to the purchase agreement. Kenyana Shacole Stone believes that the submitted true and accurate copy of the purchase agreement filed by plaintiff is materially altered.
This is just a conspiracy. It's a conspiracy.
Contract concealing the signatures of the seller, Kimberly K. Short, and seller's agent signature, Melissa Cutts. See attached to this answer a true, complete, accurate signed purchase agreement. Closing date was set for July 5th, 2023, in which it was amended in the contract to July 10th, 2023, due to seller Kimberly Short needing more time to remove all her personal property from 5710 Brook. The agreed purchase price and accepted offer for the real estate was $1,700,000.
Just don't use fake money.
With payment to be in cash with no financing requirement.
I want cash money.
See, we don't need to stop. That's the nucleus right there. Payment is to be in cash. Here we go. This is where the sovereign citizen, what do they call it, semantics games come into play. I can see it right here. In section 4, this is where she's going to try to justify something that we all just read that the government said is not legit.
Here it comes.
Now, this is their mindset. You can get perfect, straight on the face, legal authority saying, no, this is not what it is. And they will still try to justify it. It is this way. It is this way. Here we go. Kenyana Shacole Stone acted in good faith.
Oh my God. Oh my God.
How do you act in good faith when either you're going to pay in cash or you're not? How is that acting in good faith? Either you have the money or you know, we're not real money.
The rumor has it you're broke.
Acted in good faith by providing payment for the real estate property. Bank United Treasury Managed Department, overnight mail via FedEx with providing tracking number. Delivery status shows delivered. Thursday, July 27, 2023 at 9:37 a.m. Signed by W. Fernandez with proof of delivery by online FedEx tracker website. So I hope she doesn't think that just because they received it, that it's good. I hope she doesn't try to go and say tender of payment is discharged. That's another sovereign citizen thing. I hope she doesn't believe that if I give you a check and you take my check, the debt is paid. Not knowing they got statutes and regulations for reversing payment or non-sufficient funds. The only thing is when you get a check, you got to process it, bam, fast. You can't get it and hold it for 6 months. You have to process it fast. In the Century 21 Act, Check 21 Act, that's another thing you just learned that you didn't know exists.
No, that's not impressive.
It tells you, get it, deposit it, process it. But if the check gets kicked back, there is no discharge there because the money was never really there.
Zero?
See, this is the part that they really know about real money because they've been using cash, buying things their whole lives. But this is where the semantics game comes into play when they're trying to justify something that has no legal basis. That's when they play game goofy, like they don't know how everyday transactions work. Now there's another secret method that everyday transactions don't mean this, it means this now.
You play dumb with me?
Bank United Inc. is the recipient and acceptance of notary certificate of service, including documents, instruments, special letter of instructions. certificate of ownership, beneficial interest, purchase agreement, settlement statement. Why would there need to be a letter of instructions if what you're doing is the normal process? You don't need to instruct them on processing it. They know how to process these things.
Yeah, that's a good point.
If you were to give them a certified funds check from the bank manager signed, and the bank holds that money in escrow until they cash it, there's no instructions to do. They already know what to do. By the fact that you need to give them instructions on a process that is very standard and normal, and they do trillions of dollars a day, it raises suspicions off the break. Why do I need instructions on how to process this? We already know how to process it. We have a bank that the Fedwire Fund Services. We just process it there. We take an electronic image of it, send it up to the Federal Reserve. Federal Reserve is going to pull the funds from a legal valid account. If there's no legal valid account, the Federal Reserve is going to kick it back. They're going to kick it back to the bank. Bank going to kick it back to you. Like, where's their instructions for? Unless you're trying to circumvent the normal way that you know you can't produce.
You can't get past me. I see you. I see you. I see you.
Kenyana Stone was never provided in writing or verbally from Bank United Inc. or from Trademark Inc. that she was being refused for no funds received as payment. Kenyana Shakur Stone alleges that she has not failed to make payments for the purchase. The burden of proof lies on the plaintiffs to prove upon request for accounting that funds were not received and no funds were available. For commercial law, uniform commercial cost, secure transaction states upon request for an accounting means a record authenticated by a debtor requesting that the recipient provide an accounting under the unpaid obligation secured by collateral and reasonably identifying the transaction or relationship that is subject to the request. That doesn't even apply to you because no money was ever sent.
Show me the money.
You're quoting the statute. They're not a debtor to you. And she's really thinking that she's the creditor in this situation. There is no, they told you the money didn't go through. And you kept putting it off.
10, 20, 30.
And once they realized, no, oh, we about to get into that. Kenyana Shakur Stone is requesting full accounting with respect to real estate property collateral. Plaintiff alleged that payment request was refused. And pursuant to Indiana Code, negotiable instruments, tender of payment, that a tender of payment of an obligation to pay instrument is made to a person entitled to enforce the instrument. The effective tender is governed by the principles of law applicable to tender of payment under a simple contract. If tender of payment of an obligation to pay instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent to the amount of the tender of the obligation of an endorser or accommodation party having right of recourse with respect to the obligation to which the tender relates. This statute is inapplicable because you enter a purchase agreement, not a legally binding obligation.
Well,
See? And by her citing the statute, she don't even realize it killed her whole arc. And this is the same thing that the lawyers looked at, and it's the same thing the judge hit on. Look, to pay an obligation to pay an instrument, like a bill, a statement. You signed a purchase agreement. It's an agreement to buy. Meaning, was it a legally binding agreement to buy? No, because people back out of deals all the time. So this doesn't even apply to you because there was no obligation. It was an agreement, not an obligation. And these are the nuances that if you was to go to court, that's exactly how they would argue the lawyer. Hold on. There was no obligation for my partner to, like, I can't sell. It was an agreement. And if you don't meet your terms of the deal by this date, I'm going to cancel the agreement. So this is why I say they don't know how to read statutes and interpret them correctly.
stupid isn't written over here.
So number 6, everything you said, that's another X. Doesn't apply. Misinterpreting a statute is the common thing for these gurus. If tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay the interest after the due date on the tender is discharged. Once again, there was no obligation. It was an agreement. If presentation is required with respect to an instrument and the obligor is able or ready to pay on the due date at every place of the payment stated in the instrument, the obligor is consented to have made tender of payment on the due date when the person entitled to enforce the instrument. There is no entitlement on Stone to enforce the instrument because it was an agreement to pay. But you notice 6 and 6C, you notice she didn't break it down how that applied to her. She did it in 7. Kenyana Shakur Stone acted in good faith to tender payment with negotiable instrument. Isn't that the same thing they always say? And that Kenyana Stone was the person entitled to enforce the instrument. No, you're not.
I guess we just have to let stupid people believe what they're gonna believe.
Kenyana Stone never released herself or any parties in the mutual release agreement. You're not. Oh my gosh, she don't understand how real estate transactions go.
I am dumb.
You don't govern that. You don't control that. They could back out the deal anytime they want. Plaintiffs acted in negligence by listing property for sale on July 29, 2023 for $1,750,000. And on October 10th, 2023, there was a pending sale for $1.7 million. Then sold on December 8th, 2023 without any notice to Kenyana Shakur Stone, the alleged new owner of the real estate property. So I don't even need the lawyer to call me back. Once that order was removed, they moved on to another party that actually had the money to buy it.
I can't prepare one, man.
So they went with someone who actually had the money to buy it, not someone like Kenyana Stone who didn't have the money to buy it, who was trying some sovereign citizen stuff because she ain't have 1.7 M. She was stepping out of her league.
You're getting in waters deeper than you think.
Look, they sold the house. And you thinking that because they ain't accept the tender, they ain't give you this, they ain't give you an accounting, that you own the house. The house is yours now.
All right, I'm not going to stand here and defend myself.
You better defend yourself.
You done lost your mind. You see, when I said they already sold the home, Kenyana Stone was on live and said, no, they didn't. No, they didn't. They ain't sold the home.
Like, what is all this? None of it makes any sense to me.
This is why she said, I don't got to read my court case to my audience. This is why.
Oh.
But she'll make posts about what's going on in the case, but she ain't go live and review her case. I thought you was a teacher. Look, right there. December 8th, they sold the house. On November 28th, Kimberly Short texted Kenyana Stone alleging that she may have been misinformed and would like to make things right, that we had already signed papers at the title company, and she wanted to honor that Kenyana Stone was first. She would deal with the new buyers that were going to close on November 28, 2023. Kenyana, that's based on the premise that you actually really have the money. So basically, she's trying to be fair. Like, hold on, if you really got the money, hold on, I'll put them on ice. But if you really, that's only Kenyana Stone is being disingenuous at this whole process because she knows she doesn't have the money.
So I'm worried I'm going to make a couple mistakes. Most likely.
That's why she did that check payable to the U.S. Treasury. She didn't have the money. The lady is thinking people are engaging in real estate purchases in good faith. The lady would have never extended that to you if she knew you was trying this garbage.
Excuse you?
Kenyana Stone expressed to Kimberly that I only wanted to act in good faith to resolve the matter. It just needed more time clarifying the information due to the fact the title company and bank failed to respond and failed to prove and respond. No, all that. That instrument that you tendered is frivolous. It doesn't work. No money's going to be transferred. So what other acts of good faith are you talking about? You about to tender real money now? No, they know what they're doing, y'all. They know what they're doing. This ain't nothing. They know what they're doing. And this is what these teachers teach y'all to be, to move around the world being disingenuous. Plaintiffs have not shown Kenyana Shakur Stone did not secure funds.
This can't be life right now.
Yo, if that 1.7 million would have really hit, you would be in the house right now. But if that 1.7 million would have hit, you wouldn't even be on YouTube doing what you're doing because you already had 1.7 million in cash. You would be on more bigger things. On or about October 4, 2023, Kenyana Shakur Stone overnight mailed a notary protest evidencing dishonor, another sovereign citizen tactic when they don't accept your sovereign citizen documents.
You need help. You need serious help.
Now you want to fight to Bank United, giving Bank United opportunity to cure and address the instrument security received by Bank United with proof of delivery and signature of the receipt of the payment and trust property. Now she thinks those are securities.
It just keeps getting worse.
I told you they all got a vague meaning of security, vague meaning of this. They don't really understand. Bank United was given detailed reason for notice pursuant to, none of that applies, was given 10 days of the receipts to respond to the notice of dishonor due to the emergent matter concerning the payment. Bank United failed to respond in the course of fair deal and continued to default breach of their fiduciary duty because they already got notification that it was fraudulent.
I don't have the money.
On October 11, 2023, Kenyana Stone recorded the finance statement with the recorder in Marion County, listing them as the debtors and her as the trust secured party. She acted in good faith to secure all rights, titles, and interests in collateral related to real estate property. Plaintiffs granted security interests the moment Kenyana Stone had an enforceable legal claim or lien on collateral that had been pledged as purchase money security for the acceptance offer presented in the signed purchase agreement between the Stone and the Shore. None of that makes any legal sense.
What you talking about, Willis?
That's just babble. Bunch of words strewn together that looks like it belongs in a legal document. Y'all, she said nothing.
And bibbity bobbity boo is y. Put them together and what have you got? Bibbity bobbity boo, x plus y equals y, x equals 0.
Kenyana Shakur Stone believes to the best of her knowledge the purchase agreement is a secured. Look, this is where she's wrong. And she was live telling her audience this. Kenyana Shakur Stone believes to the best of her knowledge the purchase agreement itself, in which every other real estate transaction, the agreement just lays out the terms, how much I'm selling, how much you paying, representatives, this, is it going to be appraised? Are you going, you may cover this? Are you going to cover the closing costs? Are you going to take a little bit out of your proceeds to cover this? Are you going to take this? That's it. The purchase agreement itself is not anything that could be convertible into cash. Wow. I thought you knew accounting. And I thought you knew how the R's work. I told you she don't know. I will expose her on the accounting.
She cleans off the stains of the menu cards. And the thermal camera exposes fingerprints of the tourists.
She's surface level accounting. I'm deep corporate level accounting. There is a difference. Oh my God, the purchase agreement is a secured convertible promissory note, the warrant of securing payment and performance, securing secure party rights, titles, and interests in a simple contract.
And bibbity bobbity boo is y.
Kenyana Stone alleges that acting in good faith is the right to protect the trust and beneficiaries and be entitled to record and enforce the UCC finance statements against plaintiff. Kenyana Stone, with rights that are valid, having legal effect, is rejecting plaintiff's request for terminating the UCC financing statement. A true and accurate, oh my gosh, you lost this. As a result of breach of trust, breach of contract, trust and breach of fiduciary duties, plaintiffs, Kenyana Shakur Stone, the trustee, and all beneficiaries have been violated and harmed by experiencing loss due to willful negligence and acquiescence of Bank United Inc. and all other parties representing the seller.
Stop. You cap it right there.
Oh my God. Plaintiffs have damaged Kenyana Stone by being the party to which an instrument was taken for payment or collection or for value with knowledge as to receipt of payment. Plaintiffs are not entitled to recover damage, both actual and statutory, from Kenyana Stone, being she acted in good faith to comply with rights to secure interest in real estate and denies all claims of fraudulently recorded the UCC financial statement. Request for title, Liz Pendez. Counterclaims, for notice of pendency when a complaint is filed and disputes on action is pending. It is with good intention that Kenyana Stone requests the court to enter Liz Pendez with intentions to enforce the lien and clarify ownership of given property to protect Kenyana Chacole Stone recorded and unrecorded interest in real estate, not giving rise to liability for slander of title. That's something the judge does. Kenyana Chacole Stone is the alleged new owner of the real estate. What'd she say? In your goddamn dreams.
Dream on. Dream until your dreams come true.
You wish you was. I swear to God, you wish you was. Removal of order granting plaintiffs verified petition for temporary restraining order entered December 6, 2023. Kenyana Stone has all right, title, and interest in real estate located at 5710 Brookwood Road. Defendant has suffered irreparable harm due to plaintiffs acting in concert to conceal defendant's right, title, and interest in real estate property to immediately sell the property, impairing defendant's immediate right to take action to assert any and all right, title, interest, or adverse claims. But y'all realize she's doing all this. This is how I think a lot of these gurus and these sovereign center people need a mental health evaluation.
And if they were to just kind of say, look, I'm going to devote as much time to perfecting this strength that I have mentally as I do this one physically, then they would do much better.
She knows no real money ever came. So she wants to play the semantic. Well, you ain't give me a receipt. Oh, I tendered it. Hey, you ain't never sent it back. Oh, you ain't let me know. Oh, let me see. Oh, you ain't never given it to me. All right, so I must be the owner. That's how they think.
This is delusional.
And who would trust a person with this, with their own mortgage, with their own autos, with their own credit, hell, with their own court case? Who would trust them? Who would trust these people? Who would trust her? Only the people that believe the same way she does. That's it. Those are the only people that would ever, because anybody else that has a brain would know. But here's something that you could believe in. 1 second. What's good, y'all? So this was in response to my motion to dismiss because my client was being sued by a company that purchased the debt, and they filed a lawsuit. She owed $17,000. I filed a motion to dismiss, knowing that it was premature, knowing that it may get denied at this stage, because if you look right here, judge's response. But what most people don't understand is that I have top elite court litigation skills, so I really filed this motion to set a trap. So I was ordered to respond. So you can imagine that, well, if they denied your motion to dismiss, and everything in this response was the same thing I filed in my motion to dismiss. See, I set a trap not only for the company, but for the judge too, because I know court strategy and how to structure a motion where the judge is basically can't even rule against me. Now, most people would say, well, if you file the same things, double down on your position in your actual response, then to your motion to dismiss, there's no way that the case is going to move to pretrial or a conference. They're going to get awarded because you didn't win your motion to dismiss, right? But like I said, I set a trap. Now look at the yellow highlighted. You see, I pretty much handicapped the judge and not giving them a judgment right at the beginning because they wanted a judgment. But what I did with the motion to dismiss, I laid the trap, and then I came back with the response that pretty much handicapped the judge. Now it's our turn Now we're about to move for summary judgment, and this is going to be another victory. New culture. According to your conversation with your friend, the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
You're rocking with the best.
Preliminary injunction entered be dissolved due to attorney presenting misrepresented evidence that will cause injury to defendant without an opportunity for the defendant to present and answer affirmative defenses. Well, that's what happens in the temporary restraining order. The other party doesn't need to be heard in an injunction hearing. Shorts trust and all parties representing the seller have risked the whole economics of the transaction by having a pending sale and selling the house on December 12th for $1,671,000 to buyers who are now at risk due to willful neglect. No, they're not. The UCC lien recorded at the time of the sale showing property secured by Kenyana Stone Trust is still in effect. Kenyana Stone has not obstructed or interfered with ownership of the real estate. Kenyana Stone has only acted in honor. Remember that? Remember, that's another sovereign citizen word. Staying in honor. Stay in honor. Kimberly Short and Kenyana Stone. Plaintiffs are all parties representing Kimberly have harmed Kenyana with reckless untruth that affects the market value of the real estate. This is what she files with the court. A plea of tender.
What?
The only people who filed that are sovereign citizens. For a plea by special appearance. Who says special appearance? Sovereign citizens. Do you know that special appearance, it's only in the case where your lawyer shows up to court or you got a representative that shows up to court because you didn't make it?
Wow. Okay.
That's what a special appearance is. I, defendant Kenyana Family Stone of the people of the United States of America and Indigenous American Indian, Native Indianian Hoser.
Can you get to the point?
But Kenyana Stone, in your 3 lives earlier, you said you didn't use the term indigenous.
Someone is lying.
You said you didn't use that. You said you didn't say that. Why did you lie? By accommodation party for the precedent landed estate, surety for principal, Kenyana Stone, all caps, sovereign citizen. Y'all can't even lie, say this ain't sovereign citizen rhetoric. That's sovereign citizen.
You're rocking with the best.
Sovereign citizen demands the plaintiff to stop action against the surety to recover any damages or interest by reason for non-payment of the said sum, $1,702,087.40. And the declaration mentioned because on the day when the said sum became due and payable, to wit, on the 12th day of December, I acted in good faith, readily available, willing to tender and offer to pay with the plaintiff a secured certificated security.
And bibbity bobbity boo is why. Put them together and what have you got? Bibbity bobbity boo.
Not cash. She wants to pay on a cash transaction a certificated security. One of the ancient terms that they got from the Black's Law Dictionary that doesn't even apply to the transaction that she was engaged in. Why didn't you just say, I paid it cash? Here's the receipts from my own bank account showing that this money left my account. Why didn't you get a statement from your bank manager saying they did come and withdraw the funds and the money went to bank 1? You didn't have none of that evidence. Anything outside of that, you are just trying to get around with buying a house without using real money. I don't care about your version of what you think the law says. No, the actions and results matter. Why aren't you in the home? Y'all can sit there and act like results don't matter. You just sit there and listen to one, hear what you want to say. Oh yeah, that sounds inspiring. Fuck all that. Where the receipts at? And remember, Kenyana, you said you didn't have to show your case to your audience. So I said, okay, audience, I'm going to show y'all case because she don't want to show it. And I already knew why she don't want to show it. This is why she didn't respond to my text. How are they going to get paid on this? A self-created check. And let me guess, authorized representative without recourse. Huh? How they gonna get paid? None of this went through. And the biggest indicator is right there. Payable to the United States Treasury. Why are you drawing the check on the Treasury? Why are you drawing the check on the Treasury? You don't need to draw no check on the Treasury. Draw that check out your own bank account. Because that's the only thing that matters to those people. That's what I'm saying, y'all. Y'all can be fooled because y'all trying to get out of shit without paying for, because y'all have a poverty mindset, because y'all have a low-hanging fruit mindset. But the Supreme Elite team, we don't fall for this. We do things the correct way.
You're rocking with the best.
We do things the correct way. And they all teach y'all to do this. I will never teach my students to do this because I know this ain't going to work. But if she really knew accounting, was really proficient in accounting, get the mortgage, make the minimum down payment, and then work your accounting from there. I mean, come on. I mean, I'm pretty sure she knows accounting to the point where she can get a set off on a mortgage or kick up some dust where they're not collecting, or they are stopped from collecting, or they got serious issues with collecting, so they're just going to remain silent and not try to collect and try to regroup and come with the next stages. Those are good victories. Those are good indicators. I mean, you win this stuff in stages anyway. That's a good start right there. If they just automatically stop collecting after they receive your documents, now they got to go back and huddle and regroup. That's a good indicator. There's nothing wrong with that. I mean, I'm pretty sure that if she goes the mortgage way, or if any one of her clients got a mortgage, I'm pretty sure she will be equipped to help because she knows about the accounting. She knows about the transfers. She knows about the transfers and servicing. She knows about these things. I'm pretty sure she will be able to help a client if they had mortgages. I mean, I don't doubt that she wouldn't be able to. I'm pretty sure she'd be able to get this. Pretty sure she'd be able to get this for one of her clients that owed $378,000. I'm pretty sure she can get this and then call the company and confirm, yeah, that's zero's over with. I'm pretty sure she can get this.
You're rocking with the best.
Shit is easy. Child's play. These gurus is child's play. These gurus is child's play. It's child's play. Shit is child's play. Boy, ain't no fuck. The only person that I'm even going to debate, they have to be a professional in this field.